thanks to the organizers for inviting me to speak on this topic. It feels obviously very disingenuous to be talking about accountability and international law at a time when we are seeing mass violations of all basic rules of international law in Gaza and in other parts of the world as well. So I first want to echo what Penny mentioned yesterday, that, we have this privilege of being able to ignore what is happening there and talk about all of these things, talk about the law and institutions and accountability and our life. But there are people, real people, who are suffering at this very moment. So we should obviously try and do everything that we can to raise awareness about the issue, to hold powers wherever they are, however they are, to account. And it's not just in relation to Gaza, it's not just in relation to Palestine, it's in relation to Turkey, in relation to Sudan, Ukraine, Kashmir, Balochistan, everywhere. We heard the presentation by Mr. Issa, and the situation of Uyghurs is equally, terrifying. So thank you, everybody. Thanks to all the speakers who spoke before, and thanks to the organizers for putting together this conference where we had the chance to learn about other conflicts and other situations that are, of course, quite concerning and sad, to say the least. I will keep this melancholy and sadness aside and unfortunately and very strategically try and focus on the positives and see if there is a road to accountability for crimes against children in armed conflicts. This is a picture from just a couple of weeks ago where children in Palestine held a press conference outside Al-Shifa Hospital, and they just had one demand: please protect us, because they are facing serious violations of their rights. And in just the last couple of months, this is the situation. I, of course, don't need to repeat it. Everybody knows it. Almost every 10 minutes, there is one child in Gaza that is being killed. And this is just killing. There are several other violations that continue at the same time. So, in light of all of this, what am I going to do? My presentation is on the road to accountability for crimes against children in armed conflicts. And of course, conflict zones are replete with examples of violations of the rights of children. There is obviously an argument that the law in itself does not protect children adequately, and therefore that there's a lack of specific protection for vulnerable groups. But there is also an argument that the existing mechanisms that are a wide range of accountability mechanisms have their own faults, and it's that set of accountability mechanisms that I'm going to focus on in my presentation. And these are a range of mechanisms: judicial, quasi-judicial, non-judicial, and there are different types of accountabilities that they can potentially, theoretically, as well as practically bring to fore. And of course, even with these accountability mechanisms, there are a range of issues that exist, and I will try and focus on some of them. So first of all, what I'm going to do is, so this presentation is part of a broader paper that I'm writing on the same topic. What I do is I do three things. I map all the accountability mechanisms, and I will very quickly show you an infographic of the number of accountability mechanisms, sometimes those that are just informational, and sometimes hardcore accountability mechanisms like courts. I map all of those across the three regimes of international law that are relevant. So that's the international humanitarian law, law of the armed conflict, the international criminal law, and international human rights law. Once I map these accountability mechanisms, I look at whether they are in a position to be able to ensure any form of accountability. And I'll quickly go over what I mean by accountability, the definition that I use for accountability. And then I look at specific mandates and see whether the mandates and the language used in those mandates is child-specific in that do those mechanisms have a responsibility to address violations of rights of children in armed conflicts, and is there a need, according to the mandate, to have child expertise in those? And finally, I look at the gaps that exist in these accountability mechanisms and provide some recommendations, also discussing some of the existing proposals. Now, there are 6 grave violations that have been identified by the UNSC, and these are recruitment and use of children, killing and maiming of children, sexual violence, attacks on schools and hospitals, abductions, and denial of humanitarian assistance. These are, as I said, they're called as grave violations, 6 grave violations, and in just last year, there were 27,180 grave violations that the UN Secretary General reported across 24 conflicts. And the highest number of it was 2,985 killings. This was last year. Now imagine a situation where just one place, that is Gaza, has already accounted for over 6,000 killings of children. What the numbers that you will see next year in the General Assembly report will just be staggering and unfortunate. Now, as I said, I look at accountability mechanisms. They may range from judicial processes to non-judicial processes, national or international. They are quite often mutually reinforcing, but sometimes also exclusive mandates. And they operate at different levels: international, regional, and domestic. And some have a broad mandate and have a latent capacity in that that's not their exclusive or explicit focus, but because crimes against children are also sometimes classified under the broad crimes against individuals more generally, so they have that latent capacity to enforce accountability. And then there are some that are designed exclusively to prevent violations against children. And in my presentation and in my paper, I focus exclusively on international and regional accountability mechanisms, keeping aside the domestic ones. Now, what do I mean by accountability? I use, based on existing literature, I use an outcome-based accountability approach and have 4 elements of accountability. I'm not going to go over them. Essentially, accountability is just to hold people to account, and there can be different ways in which you can do this, and I use the 4-pronged approach in my paper. Now, this is the map, and the second map is here. As you can see, there are 2 types of accountability mechanisms here: judicial, and this will be at state level, the International Court of Justice, the human rights courts, for example, the European Court of Human Rights. At individual level, that is responsibility of individuals, so that will be the International Criminal Court and several ad hoc courts, for example, ICTY, ICTR, and several others. And then you have what I call quasi-judicial treaty bodies, for example, the Committee on the Rights of the Child, Human Rights Committee, Committee on Enforced Disappearance, and so on and so forth. And then you have a series of non-judicial accountability mechanisms. As I said, because I look at these accountability mechanisms across the 3 regimes, that's international criminal law, international humanitarian law, and international human rights law, there are different bodies. So under the Geneva Conventions, you have the inquiry procedure, you have the International Commission on Inquiries, you have protecting powers, then UN mechanism is a huge mechanism. Starts with the Security Council, goes on to General Assembly, then the UNHRC, several other procedures, and I'm going to specifically focus on a few of them. For example, the MRM that you will look at in a bit. And then you have other mechanisms, for example, the ICRC, NGOs, Geneva Call, and several others that also play an important role in ensuring accountability for for crimes against children in armed conflicts. Now, looking at some of the individual mechanisms, the International Court of Justice until 2019 had never had an opportunity to address specifically the violations against children in armed conflicts. Of course, the issues did arise in cases like the armed activities on the territory of Congo, where violations of IHL and IHRL were established. The Committee on the Rights of the Child has a particularly important role when it comes to ensuring accountability for crimes against children in armed conflicts, because Article 38 of the Convention requires that state parties undertake to respect and to ensure respect for rules of international humanitarian law applicable to them in armed conflicts which are relevant to the child. So, and there is the optional protocol to this convention that allows for individual complaints that can be made about violations of children in armed conflicts. Interestingly, there's this International Humanitarian Fact-Finding Commission, which is under Article 90 of Additional Protocol 1 to Geneva Conventions. The first time that it ever initiated an investigation was in May 2017. It was not related to children. It was a completely different explosion that happened. But there is this mechanism that has not been used ever. That's a very important part of Geneva Conventions, which are, of course, the law that govern armed conflicts. Now, the UN mechanisms, as I said, of course, my presentation, my slide is text heavy. You don't need to read all of it. Just probably listen to what I'm saying, and I'll try and distill some of the main things from this. The UNSC has several types of, accountability, both hard form and soft form, and uses various means to ensure accountability for crimes against children in armed conflicts. That's through public condemnation, sanctions, and the Working Group on Children and Armed Conflict. The Security Council also adopts thematic and country-specific reports, and the country-specific reports are generally, they're quite important in that they bring to forth what is happening in those countries and provide certain recommendations that those situations can take into account. The sanctions regime, on the other hand, of course, I do not wish to propose or prescribe sanctions regime, because we also need to look at the disproportionate impact that sanctions have on the civilian population in several of these regions. But the sanctions regime is one of the stronger accountability enforcing procedures that authorizes targeted sanctions. And I think the UN sanction regime specifically designated killing and maiming of children in DRC in 2006, and Somalia in 2011, and South Sudan in 2015. So specifically for crimes against children, these are situations where this sanctions regime was enforced. But of course, it is quite notorious for using inconsistent criteria in designating persistent perpetrators, even when similar violations take place. So, for example, while killing and maiming children was used as a criteria for South Sudan, it was not used for Somalia, even though it was the same violation. The working group performs an advisory monitoring function and also, works quite closely with the Secretary General, which I'll come to, and the other way in which the Security Council can ensure accountability is through referral of a situation to the ICC, as we have seen that in the recent past. The General Assembly in itself, of course, does not have any enforcement powers, but can act as a crucial norm creation, has a crucial norm creation function in relation to protection of children in armed conflicts. What is quite important is the role of the Secretary General. And of course, all of you must have seen the desperate calls that the Secretary General has been making in relation to Gaza. and the attacks that he has been facing. But nonetheless, the role of the Secretary General is quite crucial because with the support of several special representatives, including one that I will discuss, that is the Secretary General on the Special Representative for Children in Armed Conflict, the Secretary General creates a lot of awareness about this and feeds into the Security Council's accountability mechanism. And based on these reports, the Secretary General creates a report and then sends it to the Security Council and also to the General Assembly. Now, the Secretary General's report on children in armed conflict is crucial because it has 2 annexes. And parties that are listed in these annexes are the ones in relation to which there is the monitoring and reporting mechanism that comes into picture. So once someone is listed in this, there is the naming and shaming mechanism that comes into picture. And you must have heard in the last few weeks there have been calls asking the Secretary General to list some Palestinian armed groups and the Israel Defense Forces in that list, so that then that brings into picture the MRM, which is the monitoring and reporting mechanism. The Secretary General last year included Russian forces in that list and therefore is doing a lot of advocacy to ensure that there is protection of children. The MRM, it's an interesting and quite an important sort of accountability mechanism here because MRM is established once a situation or a country is listed in Secretary General's report in the annex, right? And there are, I think, 24 such situations, such groups that are currently on the list, but I may be wrong, it might be updated. It was set up in 2005, and it gathers systematically information on these 6 grave violations. And this is one of the very specific and exclusive mechanisms of accountability for crimes against children in armed conflicts. And it creates this feedback loop in that the information that is collected by the MRM goes into the report of the working group to create more accountability. So the Secretary General creates a list. These are the parties that are engaged in systematic or persistent violations of children, rights of children in armed conflicts. That goes to the Security Council. The MRM comes into picture. MRM gathers more information, more monitoring, and then it continues. The cycle continues, and it's an important monitoring mechanism. And over the years, it has, had several instances where MRMs have been in place, and the approach not only creates deterrence-based accountability, but could also potentially lead to impositions of sanctions through the UNSC. So if the same party is mentioned in the annex over and over again, then the Security Council might, as it did with Sudan and Somalia, impose sanctions, particularly for violations with respect to children. However, I mean, we heard a very strong indictment of the UN yesterday once again, and the process is quite politicized. The listing process is quite politicized, both sanctions as well as listing in these. And states are quite wary. They're scared of being included in this list, so they do a lot of lobbying to stay away from this list, and that creates, obviously, gaps in protection. And it's best illustrated by, even though there were significant and serious violations of these grave, there were 6 grave violations in respect of Palestine, the Secretary General's list, despite such evidence, did not include IDF or some of the Palestinian armed forces in its list. And of course, that creates a lot of problems. It not only undermines the legitimacy of the MRM, but also, deprives children of their protection. And then there are, of course, faulty delisting and very lax post-monitoring, post-delisting mechanisms. So what happens once an MRM takes place is that there is an action plan that is agreed with the party to the conflict. So if a party is listed on the annex, there is an action plan, and that according to that action plan, they have to take concrete steps to ensure that they get out of this, right? And sometimes they do some of these things just to get out of it, and there is no real accountability following that. If the violator continues to violate, there aren't too many accountability processes. The only thing that can happen is that they are continuously put on the list. And MRM continues to operate there by just reporting, monitoring, reporting, monitoring, reporting, monitoring, and nothing more than that. And the other thing is that the MRM is triggered only in relation to 5 of the 6 grave violations, and it does not is not automatically triggered in relation to a denial of humanitarian access, which is denial of humanitarian assistance, which is one of the grave violations, and that's a gap that we see here. Then, of course, criminal courts and tribunals, especially in relation to the international criminal law, these are important accountability mechanisms, and according to scholarly literature, the greatest benefit of these courts is that their high-profile prosecution and convictions achieve deterrence at a direct and micro level by putting individuals on notice that the ICL, which is international criminal law, has a real reach. And it was in Lubanga case that the defendant became the first person to be indicted by the ICC solely on charges of recruiting and using child soldiers. And of course, there is a lack of focus on other grave violations, and there are several other challenges, including the limited ratification of the Rome Statute by this. And then there is obviously a lot of problems, then a politicization that states have, for example, the US and Israel as well, whenever the ICC takes any proactive measures there. There are international human rights law treaty bodies that are important mechanisms as well. As I said, the the Committee on Rights of the Child, Article 38, is an important mechanism, but unfortunately, there is limited engagement even of the Committee on Article 38, and that's in fact, one of the recommendations that I make towards the end. Now, overall, I think that individually these are accountability mechanisms, and put together they create an accountability system. And even though one of them does not necessarily lead to accountability fully, but they feed into one another, and there is definitely some merit to having these systems. But even then, there are serious deficits or defects that this accountability system has. First of all, there are no proper and legal ways to hold non-state groups to account. It's only states that are generally held to account. And second, the existing system rarely takes into account the peculiarities of grave violations. And of course, I can discuss that in questions later on. Then in relation to, I'll just take one more minute. I'm very sorry to be in between you and the end of the conference. But my mapping of all of these mandates revealed that the specific mandates do not have any child-specific language, but the resolutions that renew their mandate or that set them up. And this is quite interesting in that the resolutions, the Security Council or the Human Rights Council or the General Assembly will put together a resolution to set up a body. In that resolution, they will make reference to crimes against children in armed conflicts, but then the mandate of the body does not have any reference to crimes against children in armed conflicts, which is an important, something gets lost in between the resolution and the actual mandate, and that's a problem. And of course, to bridge the gap, there are three major proposals that have been made. One is the greater ratification of Rome Statute. Second is to improve ratification of the optional protocol. And then the third is creation of an entirely new legal instrument on the rights of children in armed conflicts. All three have significant inertia issues in that states would be unwilling to do this, especially at a time when international legal system is being seen as biased by one and all. So some of the recommendations that I make are, of course, this is not to say that I don't think that the previous three proposals are not worthy of perusal. We should continue to pursue them, but those, I think, are long-term proposals for road to for the road to accountability for children in armed conflict. And I think there are certain small, actionable things that can be done to ensure that the existing mechanisms that we have are made better use of to ensure protection of children in armed conflicts, whether that is greater awareness about the specific mandate of the committee, or the consistency in the MRM and UNSC sanctions, or using child-focused expertise, as well as ensuring that there are deeds and commitment action plans that are entered into with non-state armed groups. That would be, I think, quite helpful in ensuring accountability. And finally, that there are all of these, as I said, when I showed you that huge list, there are at least 20 to 25 agencies and bodies that have some role to play in accountability for crimes against children in armed conflicts. But there is so much of disparity and so much of individuality in them that they don't speak to each other. And I think that's a huge problem, because there are places where one body will definitely benefit from the expertise of another and can help one another and create that accountability system. So I recommend, in my paper, of course, I give a detailed explanation of this, that there should be a supervisory authority, for example, the Security Council or the General Assembly, that can set up a procedure for regular performance evaluation and management of all of these, and to coordinate their actions. Yeah, thank you, and sorry for being over time.